Good day, everyone. Today, I will present our case digest regarding the case of Estela L. Crisostomo, the petitioner, versus the Court of Appeals and Caravan Travel and Tours International Incorporated, the respondents. On May 1991, petitioner Estela L. Crisostomo contracted the services of respondent, Caravan Travel and Tours International Incorporated, to arrange and facilitate her booking, ticketing, and accommodation in a tour of Jewels of Europe. But without checking her travel documents, petitioner went to NAIA on Saturday, June 15, 1991, to take the flight for the first leg of her journey from Manila to Hong Kong. To petitioner's dismay, she discovered that the flight she was supposed to take had already departed the previous day and learned that the plane ticket was for the flight scheduled on June 14, 1991, thus called up Minor to complain. For its part, respondent company, through its operation manager Concepcion Chipeco, denied the responsibility for petitioner's failure to join the first tour. Respondent explained that it can no longer reimburse the amount paid for Jewels of Europe, considering that the same had already been remitted to its principal in Singapore, Lotus Travel Ltd., which had already billed the same even if petitioner did not join the first tour. Lotus European Tour Organizer, Insight International Tours Ltd., determines the cost of a package tour based on a minimum number of projected participants. After due proceedings, the trial court rendered a decision, the dispositive part of which reads, Wherefore, premises considered, judgment is hereby rendered as follows. Ordering the defendant to return and or to refund to the plaintiff the amount of 53,989 pesos and 43 centavos, with legal interest, thereon at the rate of 12% per annum starting January 16, 1992, the date when the complaint was filed. Ordering the defendant to pay the plaintiff amount of 5,000 pesos as and for the reasonable attorney's fees, dismissing the defendant's counterclaim for the lack of merit, with cause against the defendant. Respondent appealed to the Court of Appeals, which likewise found both parties to be at fault. However, the appellate court held that petitioner is more negligent than respondent because as a lawyer and well-traveled person, she should have known better than to simply rely on what was told to her. This being so, she is not entitled to any form of damages. Petitioner also forfeited her right to the Jewels of Europe tour and must therefore pay respondent the balance of the price for the British pageant tour. Wherefore, premises considered, the decision of the Regional Trial Court dated October 26, 1995 is hereby reversed and set aside. Petitioner contends that respondent did not observe the standard of care required of a common carrier when it informed her wrongly of the flight schedule. The instant petition is denied for lack of merit. The decision of the Court of Appeals, in Court of Appeals, General Register, CV number 51932, is affirmed and accordingly, petitioner is ordered to pay respondent for the amount of 12,901 pesos, representing the balance of the price of the British pageant package tour with legal interest, thereon, at the rate of 6% per annum, to be computed from the time the counterclaim was filed until the finality of this decision, and after this decision becomes final and executory, the rate of 12% per annum shall be imposed until the obligation is fully settled. This interim period being deemed to be by then an equivalent to a forbearance of credit. Since the contract between the parties is an ordinary one for services, the standard of care required of a respondent is that of a good father of a family under Article 1173 of the Civil Code. This connotes reasonable care consistent with that which an ordinary prudent person would have observed when confronted with a similar situation. Contrary to petitioner's claim, the evidence in record shows that respondent exercised due diligence in performing its obligation under the contract and followed standard procedure in rendering its services to petitioner. Therefore, it is clear that respondent performed its prestation under the contract as well as everything else that was essential to book petitioner for the tour. The negligence of the obligor in the performance of the obligation renders him liable for damages for the resulting loss suffered by the obligee.